Well, do you think Matthew Fardwell from the Sandra Birchmore case and KOURI Richins from the I'm just filled with grief case are sharpening their hacksaws to break out of jail, Michael Bryant?
I don't know if somebody's going to deliver a cake with them. I don't know. This Farwell thing, it's not a certainty. Could the case against him be dismissed? We'll talk.
Justice, where are you? Michael and Linda are here.
I love you, Linda.
What is justice? Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and Damil, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Well, it feels like Monday to me.
That's because you weren't here last night.
That's
And
right. That's
Neil
right.
Rockin, Rockheim, I call him Rockin.
the Rockweiler.
Neil, the Rockweiler,
Mm-hmm.
and Jodine Weber, Jody. They did a great job co-hosting with me. As a matter of fact, I turned the show over them to start doing really co-hosting. And boy, did they both get into it. I was like sitting there waiting. And then once in a while they'd say, well, we'll throw a question to you. And I'm like, I have to work now,
Yeah, let me just watch you and them fight. That's the way to go.
It was fun. We missed you, but they did a great job.
Good. Yeah, I did a little report from down below there in Florida and gave away a mug. Interestingly, I got to reach out to our mug winner. We'll work it out, but I had some flash of a way to deal with it we haven't in the past. Let's just say she doesn't live in Ireland. Let me put it that way. So,
Hi, Sheila Duffy.
So you got some options. You got some other options. Sorry, Sheila Duffy. Anyway, so let me do this real quick before we get into our stuff. Here, this is it. This is live. I think it's live. Let's see. Let me hit a button here. I think it's live. Let's see.
It was live when we just got on the air.
Yeah. So this is what's been going on all day, and we're going to circle back to the KOURI Richins case, day 7. This is the accountant extraordinaire who's been on all day. This is now redirect. Cross just finishing. But we're going to get into that, some of the high points, low points. I actually, I'm not normally into the accountant, but because it's all about real estate, transactions, fixing homes, flipping homes, stuff that I've done for decades. So I kind of relate to the testimony, and maybe in a way that jurors won't, because they're talking about big numbers and debt and, moving money from this account to this account.
They're talking about floats.
Well, they are talking float.
But they're also talking about, I don't think you've ever attempted or been charged with attempting to kill or murdering a spouse.
No, not yet, but most of the deals have been more, favorable. So anyway, so before we get into that, though, because tomorrow is the hearing in the Matthew Farwell case, remember his attorneys have brought a motion to dismiss in the federal case relating to the death of Sandra Birchmore because she was a witness. So she needed to be rubbed out, according to the government. Government filed their response. When we did this last week, it was on the eve of their response. They hadn't responded yet. And it happened, I think they responded on Friday.
Right. Here we are.
And now we have it, finally.
Hot little hands.
So we're going to go through that because that case is of supreme interest at this point. And then we'll circle back to the accountant as we get toward the end of the year.
And we have 2 episodes on that. If you after you finish the show, if you want to go back and look at the 2 episodes we did on that, it was first for members, and we broke it up for all of you subscribers and even non-subscribers can get into it about how this motion may have some juice. So when we analyze it in the show in a few minutes, you're going to see whether or not the government responded to our criticisms of actually the charge, as it turns out. Who knew?
That's right. They had some time to listen to us before they filed, so who knows? All right, but in the meantime, I said in the meantime. All right, then. What are you ripping and reading?
Yeah, okay. So let me put the first one on because this was requested by
people requesting stories for rip and read.
If we did a rip and read on this on Cher's son, Elijah Almond. Greg Almond was his father, and he's a late musician, right? Was arrested twice. Okay, he was 49.
Who's the mom?
Well, you're taking my
Oh,
thunder.
okay.
You're taking my thunder. I was
I
going to get
didn't answer
there.
the question. I just posed the question. Okay, go ahead.
Okay.
Continue.
All right. Was arrested. Was arrested in New Hampshire twice. All right. The first one was a disturbance in the dining hall of St. Paul's School in Concord. He said he was a prospective parent. There's a little problem with that because he doesn't have any kids. All right. He was charged with, it was just a detail, 2 counts of simple assault, 2 counts of criminal trespass, and criminal threatening, as well as violation of disorderly conduct. And then he was released on bail. And then soon thereafter, right? Soon thereafter, at least he's arrested again. He broke into somebody's house. He's found on the couch, casually smoking a cigarette. And he's really cool because he's got a really cool mom who just appeared at the all the fashion shows in Milan last week, and she's got a 25-year-old boyfriend, and she's hot to trot, and she's fabulous, and she's wonderful, and her name is all at once Cher. Yeah, and one of the few people that can be known by one name, Cher, Madonna. You know,
how old is she now? Do we know?
Cher is 79.
Oh my gosh.
She's a baby.
Amazing.
She's a baby. She's a baby. Yeah, age is, you know, I mean, look at Dick Van Dyke. Look at look at Harrison Ford. I mean, you know, people are like focused on age. Just, you know, forget the age. I mean, you know, it's what you can do. So she has
a new boyfriend that you said is 25 or 25 years younger? Oh, he's 25.
25, yeah.
So he could be her grandson.
Well, you know, good for her. Good for her, Michael Bryant. All right, famous men always have younger women on their arms, right? All right. What's good for the goose is good for the
I have
ganders.
no problem with it. No, don't overreact. Don't blame me like that. No. I'm just trying to put it in perspective. The ages. Okay.
Yeah. So we'll see what happens to him. Yeah, obviously, either some type of psychiatric or some type of drug or alcohol problem, obviously, that he's wondering. He didn't hurt anybody. He just broke into a house. Now, breaking into a house is not a good thing. You wouldn't be happy if you came home and someone had broken into your house, a la Mrs. Guthrie, somebody broke into her house when she's sleeping in her bed. So there, you know, even though it can be the same type of crime, there are different, shall we say, degrees. And obviously, he didn't put up a fight. And we'll see what happens, whether rehab is going to be in his future, because that's what it sounds like to me, Michael Bryant and all. So that's my first rip and read. You want me to do all mine?
Yeah, go ahead, because mine are kind of a self-absorbed theme. So
okay, well, let's look at this one. Immunity. Okay, I didn't take a great screenshot of that, but this is the issue. The Supreme Court has struck down unanimously, and in a unanimous opinion. We've had several of these unanimous opinions.
Yeah.
Okay, in this past couple of days, I can't believe it. Private prison immunity. And that's because so many of our prisons, what they argue is that they're akin to performing a governmental function. And like 30 years ago, the Supreme Court did say, like in a medical case, yeah, you are akin to performing a function. But that's when there was only like 1 or 2. Now almost every prison or jail has, shall we say, subbed themselves out, rented themselves out to be run by private contractors, right? And therefore, it's not so easy anymore. And so they said, no, you know, we're not going to fast track this case where you're seeking that. We're not giving you GO Group the private prison immunity. We'll see what comes when we get specific, if we get jury verdicts and all. But that's a really big thing, because it's the first time there's been a little glitch in the issue of qualified or absolute immunity for anyone that represents, shall we say, law enforcement, even if it's to run a prison. All right.
Yeah. So it's kind of government adjacent, and it's a very interesting issue, which is why the Supreme Court decided to weigh in. They don't just look at stuff that's been decided. This is very interesting, and it's going to get more and more broadly applied because, as you say, that people in the business of running prisons, the government is stepping away from that.
And this is the second decision in, like, you know, the past 3 days. It's been unanimous, because there was Neil and I discussed last night the one that says, hey, if you've got your client on the stand as a defendant, you can't talk to a lawyer ever, even in direct, even to say, hey, just calm down, relax, you're doing a good job. You can't talk unless you're conveying a plea deal. So, but interestingly enough, we seem to have some unanimity among the Supreme Court. Who would have guessed? Okay. And then, because I'm on the issue of the Supreme Court, let's add this one to the stage. This is the Supreme Court had an argument yesterday on the issue of a Texas man who was charged that he violated federal law prohibiting the possession of a gun by users of illegal drugs, whether or not that could go forward. And the Supreme Court seems to be a little bit reticent now. There's a whole thing with states where, if you had a felony conviction for drugs, or if you were a user of drugs, you couldn't have a weapon or a gun. And I think it's because so many people in the United States have family members and have issues with drugs and minor drug convictions, even felony convictions for drugs, as long as you're not a big drug dealer, distributor. And I think they're going to strike down the fact that there's laws out there that bar people who have drug convictions from having a gun under the terms that those violate the Second Amendment.
Okay,
Right
two questions on that. First of all, are they talking about all drugs, or is it just THC products? What?
No, actually, they're talking about more. They're talking about anyone who has an unlawful user of an addicted to any controlled substance. So they're talking about all drugs.
That's
so
a little,
maybe
that's a little broad. Okay.
Yeah, maybe if they come with an opinion, they'll say something. Maybe if you're Schedule 1, whatever.
Well, and that's
not
true. Tier 1,
Yeah.
Tier 2, et cetera, et cetera. I mean, that is different, and obviously THC was removed, right, from the top level, wasn't it? Removed by the administration.
Right, and
that's
let's talk
interesting.
about this. Is really interesting. Let's talk about this because Judge Coney Barrett had a concern about what if you have a prescription for sleeping pills, right? Ambien. You have a conviction for possession of Ambien, right? But your spouse has sleeping pills, and you can't have a gun in the house because your spouse takes sleeping pills. I mean, it does seem in today's world, the way you have all sorts of issues that I think they're going to strike it down. Maybe they'll put some parameters on it, but I think they're going to strike it down.
They might have some direction for you. Of course, if you have a felony conviction in general, you're not allowed to have a gun. So they're not.
That's been an issue, though. That's been an issue for Amy Coney Barrett. Remember in the Florida case?
I think I don't know. I'd be surprised if they get into that. If they can do it in the context of drugs, but they can minimize it to something less than a felony, because there's a ton of drug charges and convictions that are misdemeanors, tons of them.
Right.
That would be pretty broad to ask that be the reason somebody not be allowed to have a gun. And then somebody's going to make the argument that, well, I don't take any drugs, but I'm drunk every day.
Well, that's
so I'm good. So
that's the other thing. So those were my 3 rip and reads for today. 2 were actually really legally focused, but they affect so many people. And the issue of qualified immunity has been so bandied around that I thought our viewers would be interested in it.
I think you're right. I got 2 that they're ongoing issues, and they both relate to Freedom of Information Act related matters. People will remember I got the phone logs from the Donna Adelson journey to prison. She's in prison now, not in jail. They sent the logs, and there was 3 or 4 very specific phone calls that I thought might be interesting. So I requested those recordings, which we have a right to listen to. Unless it's with the attorney, obviously those are privileged. I itemized them by the date, the time, the page in the report I got from the Department of Corrections. And a month later, crickets, nothing.
Wow.
Except online it says in progress. That's it.
Wow, that's like the download of my new maps for my car. It's in progress. It's been in progress for like 48 hours. Right?
My download is failed. That download failed. So I sent another note to find out where the hell everything is, because that's not an acceptable response.
Was it a nice note?
Well, I didn't curse. I just said, what's the deal? It's been a month. I know where these calls are. I showed you the log information. Can't be that hard to find. Not like I'm telling them to go through years of logs. Here are the dates, the times, the phone numbers. Easy to find. So then I also found out from the Massachusetts State Police, where I've been asking for body cam footage relating to, the known agitator. The known agitator videos from when I was up there are identified in the materials provided in the context of the lawsuit against them that's brought by myself and others. And so, again, easily identifiable, the place, the time, the subject, and we know they exist because they said so in their own logs. So I sent them a follow-up note, and they actually responded. And maybe this is a robo response. I don't know. Let me first tell you what the request was, so you can see how specific I was. Any and all body-worn camera footage from April 1, 2025 through June 18, 2025, that's the trial, basically, taken by any member of the CAT team at or near the Dedham Superior Court during the course of the Karen Reed criminal trial. Any and all included reports between April 1 and June 18, naming Michael Bryant, and I even spelled my name the second time wrongly, Michael Bryant, Thomas DeRozier, Scott McGinnis, John Delgado, or any other persons involved in any other incidents as reported on MSB field incident or field in interview documents. Note, if a separate request needs to be made for each individual, please advise. In the absence of such notice, this requesting party will rely on this request as sufficient as detailed. So, your request is considered a submission pursuant to the Massachusetts Public blah, blah, blah. Blah, 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 blah. The monitor and the monitor? Oh, to monitor the progress. Oh, wait a minute. I got the wrong page. Doggone it. When I put the right page here. Hold on.
Yeah. Okay.
Hold on. Is that the right page? Oh, I must have hidden the right page. Here's what they said, though. We're getting overwhelmed with requests. So we do these in the order in which they're received. So we appreciate your patience, but we're doing these as quickly as we can in the order received. So I can kind of believe that because I'm sure from various sources on different cases, on different grievances, people are inundating the Massachusetts State Police with requests for materials, etc. So I will give them a slight break, although it's been a month. We'll keep you posted on that. Not so much for the Department of Corrections in Florida. They have no excuse. Okay.
You're really right. That's really, I mean, you're on them. You're on them. And Michael Bryant's on you.
The funny thing is, other than sue them, like Ashley Merchant had to do in Fulton County, they can keep putting you off for a while. They can be real goofballs and put you off for a while. Okay, so now, before we whiplash back into the KOURI Richins case, which will be probably wrapping up this hour for the day anyway, and it's been accounting. Lots of accounting. We're going to get into that, but before we do that, let's get into what's going to happen tomorrow in federal court. This will be in Baden. Okay. This will be in Baden. So the lovely courthouse that overlooks the harbor. So let's see if we can make this a touch.
But we're not going up there. Just so everyone knows.
Because no, we're not. To be honest, I kind of, after going up last week and then being gone over the weekend, just getting back last night, I'm like, I'm sorry. I can't.
And it's federal court, so you can't, it's.
I mean, I could go in and, I can, obviously watch it and report on it, which is interesting. But too much over the last day or so. So I'm wimping out. So this is government's opposition to motion to dismiss for failure to state an offense and lack of specificity, which we got into, as Linda said, in great detail over a two-parter. So, and we were trying to anticipate, well, what are their arguments going to be? Because you've got hold on a second. Domino is, Domino's done. Oh, there we go. Rescue the dog. The dog has been rescued. So we were pointing out that their claim seems to have some merit, that they suggest that the complaint, remember, this is a motion to dismiss, which means it is limited to the four corners of the document. Whatever is in here is being attacked, right? And it's in the superseding indictment because they had one. Why? Because they added the death of the unborn child as a second count in terms of the witness intimidation, which is how this federal case plays out. It always seems so weird. It's a case in which somebody was murdered, but it's not a murder case. It's a witness elimination case. So
yeah.
It's just weird. It's just odd. Anyway,
and remember, we thought they had added the death of the child to give some, shall we say,
the death penalty.
For the death penalty, and then they decided not to go for the death penalty. So
and remember, this is
negotiation.
It's all going on in federal court because the state has wimped out on this thing, and have not filed any charges and still believe that Sandra Birchmore killed herself. So they've painted themselves in that corner. And that puts a lot more pressure on this federal case because it really is not the best place for this to be tried. But it is, because now somebody's going to try and hold Matthew Farwell and perhaps his brother and others responsible for the death of Sandra Birchmore. So specificity is the key to the indictment and the superseding indictment. One of their challenges, and I'm going to just lay it out here, Farwell argues that the superseding indictment fails to state an offense and lacks the required specificity because it does not identify a federal law enforcement officer to whom the victim would have reported the defendant's underlying federal offenses. And of course, that would be Farwell trying to rub out a witness to avoid culpability. He also argues that the superseding indictment should have included specific language from the Supreme Court's construction of the intent element. Okay, so those are the basics. Those are the two big issues. First, and this is their response in broad language, the superseding indictment does identify a federal officer as the putative target of communication regarding Farwell's underlying crimes. It alleges that Farwell killed Birchmore intending to prevent, quote, the communication by any person to a law enforcement officer of information related to the commission of, or possible commission of a federal offense, end quote. Now, what Farwell is saying through his attorneys, I don't think Farwell is saying it himself. That's not good enough. That's not good enough. The fact that they said to a law enforcement officer and didn't specifically say a federal law enforcement officer, then this is fatally flawed. That's what they're saying.
Right. That's what the defense is saying.
So the argument here is the term law enforcement officer is defined by statute as an officer or employee of the federal government. So they're saying, well, we don't have to say that. It's implied, it's buried in the definition. We're in federal court. We're using federal law. Therefore, we don't have to be duplicative here. Now, let's be honest. Somewhere in writing this document, they might have thrown that in, and maybe it slipped up. Maybe they didn't think about it. Now they're caught, having to kind of shuffle a little bit. And would it have been better had they repeated the word federal before? Yeah, would have been. Then they'd have nothing to fight about here. But that's, Linda, that's a lot of what lawyering is. It's finding
exactly.
the little things and making the other side get defensive and fix it, or perhaps not. So, I mean, with that alone,
but this doesn't really fix it, though, because I think what the defense was saying was you didn't give the specific name of the federal officer, and that's what we need to know.
That's like a subtext. Yeah. So, second, the superseding indictment need not allege the Supreme Court's reasonable likelihood. Remember, that was one of the law's axioms we talked about, that there has to be the reasonable likelihood that somebody's going to rat it out to the federal authorities. Not just that it's a possibility, but it is reasonably likely. And they say, no, that doesn't apply here. An indictment is generally constitutionally adequate if it, quote, specifies the elements of the offense charged, fairly apprises the defendant of the charge against which he must defend, and allows him to contest it without fear of double jeopardy. The dog's going to be in double jeopardy. Indeed, the court has held, if an indictment describes all the elements of the charged offense using the words of the relevant criminal statute, it is usually sufficient for purposes of surviving a motion to dismiss. That's the key. This is not the trial. This is not even a paper trial where you'd have a lot of discovery that would be used against one party or the other. This is on the face of the complaint. How often will a court dismiss without leave to amend a motion to dismiss? 1%, 2% times, they generally will say, okay, you could have done this better. Maybe it's a technical issue. Fix it. Yeah, your muffler. Fix your muffler.
What'd you call it? You fix what?
There used to be a commercial for Midas mufflers. Do they have Midas mufflers back east, or is that a California?
No, they used to have it in Jersey. Jersey.
Okay, so that was one of the big. Your muffler. You fix your muffler. Fix it. So, referencing Fowler, I'll skip past that. It's just Hornbook law, basically. Third, against the backdrop of the pleading requirements of the First Circuit, the defendant's challenge is to the absence of specific information regarding the theoretical communication also fails. Moreover, any further detail necessary for the preparation of the defense and to avoid prejudicial surprise can be achieved through a bill of particulars.
Well, that's what you and I talked about. That you can ask for a bill of particulars, but that usually is
explain.
Yeah, right. Explain. A bill of particulars is when you say, "Hey, prosecution, I can't defend myself properly under the Constitution with what you've given me in this indictment. So I want you to give me a bill of particulars of what I'm actually charged with and how I'm violating the law. It's more detail than that, but it lists down 1, 2, 3, 4, 5, 6, 7, 8, 9. It's almost like a discovery request when you come right down to it.
And so the feds here are saying, look, you got all kinds of remedies here. You know, don't be such a weenie. Just, you know, take what you have at this point through discovery and a bill of particulars. If you want to put one together, we'll provide that if you ask for it. So, you know, the goal is quite often to give the court many reasons to decide in your favor, or in this case, give the court many reasons not to grant the motion. Or if you're going to grant it, we'll fix it. We'll make everybody happy. We'll take the leave and amend. Legal standards, I'm going to go past that just because it's a lot of Hornbook law, and we're not going to
explain what Hornbook law is. You made me explain the bill of particulars.
Yeah, okay, I will. I probably have a few times in the past. It's generally accepted principles of law. You know, it's not like this issue with the gun ownership and, you know, controlled substances. That's a brand new, fresh. You know, you couldn't cite that anywhere in a brief, and people go, "What the hell are you talking about? That's not settled." Hornbook law is settled law, that just general principles that apply, and very important, but can be kind of boring. So we've hit the high points. We hit what the arguments are about. So let's get to the argument, shall we? Okay, here we go. Farwell's motion to dismiss count 1 should be denied. Farwell contends the count 1 of the superseding indictment should be dismissed because it fails to allege the communication would be to a federal law enforcement officer, fails to allege the reasonable likelihood language from Fowler, which is the Supreme Court case they're relying on, and fails to allege specific facts identifying the exact route. Do you say route or route?
Route. I say route, but the
I think
route
that's East Coast too.
Yeah.
I think route is West Coast. Okay. Let's take a poll on that. Routes and routes. Let's see. It fails to allege the specific facts identifying the exact route through which the theoretical communication would have traveled had Birchmore not died. These contentions
I'm going to actually stop you because there was a famous TV show called
Route 66.
Route 66.
Yeah, they didn't call it Route 66. But when I was young, I had a paper route. I didn't have a paper route. I had a paper route. So
interesting.
That's where mine comes from.
Okay, chat. Where do you lie in on this?
Let's have a poll. Route versus route.
Route versus route. I mean, you know, we started the show with share because there was only one way to say that. So, you know.
Sure.
Share. Not sure. Yeah. Oh, gosh.
Okay, let's see.
He's back. Michael Bryant's back in case you missed him.
Count 1 of the superseding indictment charges Farwell with killing a witness and then they cite the code, whoever kills or attempts to kill another person with intent to prevent the communication by any person to a law enforcement officer or judge of the United States of information relating to the commission or possible commissions of a federal offense shall be punished as provided, blah, blah, blah. That's where death is an option, but not always. Okay, so again, the reference here is to a judge of the United States or law enforcement officer of the United States. Well, it's federal. They didn't say federal. Part 2, the term law enforcement officer means an officer or employee of the federal government or a person authorized to act for or on behalf of the federal government. Is that like a company that's running a prison? Or serving the federal government as an advisor or consultant authorized under law.
Wait. That's the words I like. Advisor or consultant, because then that could be almost anybody, right? It doesn't say even paid advisor.
Yeah, it's you know, we always think of things in terms of an agent of the state, agent of the federal government. I you know, based on this definition, it's a pretty loose affiliation to be considered part of law enforcement.
Well, that brings us to the point. We have federal admissions, right? We're admitted to the Supreme Court of the United States. I'm admitted to, I can't count how many district courts. Am I an agent?
District of California. That's where I'm in.
Okay, so and we are officers of the court. Does that make us federal agents in terms of this law?
Wow, that's
there you go. Okay,
I would say no, because any of the consulting we might do or advising is not for the court or court personnel. It's for our clients who happen to be appearing in front of the court or court personnel.
Interesting.
So I would draw that distinction. Yes, we're consulting and we're advising, but not the government.
I mean, you know, we started the show with share because there was only one way to say that. So, you know.
Sure. So that's I would draw that distinction. Yes, we're consulting and we're advising, but not the government. That's just my take. Let me know when that gets before the Supreme Court. Okay. Additionally, Congress eliminated any mens rea requirement. What's that?
Intent.
The intent regarding
specific intent, not just intent.
Not general intent.
Specific intent, not general intent. And there's a difference between specific intent and
Oh,
general
my.
intent. So now I
ahead.
go back to
Go ahead, Professor.
I separated out for you. Now I'm going to let you define it.
Well, usually it's done in the context of a given crime. For example, murder, generally a specific intent crime, whereas burglary may or may not be a specific intent crime. It means that you intend the consequence of your actions.
Yeah, general intent, because you may break into somebody's house, but you were meaning to break into somebody else's house. So
yeah, so you meant the act, but it's more. It's not like breaking in to steal A, B, or C. Then maybe you have a better chance of proving the specific intent. But it's a harder level of proof, which is the bottom line in terms of. And it's usually for more serious crimes. You have to have specific intent. So they're saying Congress eliminated mens rea requirement regarding the federal status of the putative recipients of a communication that the killing prevented, stating, in a prosecution for an offense under this section, no state of mind needs to be proved with respect to the circumstance. 2, that the judge is a judge of the United States or the law enforcement officer is an employee of the federal government or a person authorized to act for or on behalf of the federal government or serving the federal government as an advisor or consultant. So that I think reinforces my analysis of appearing in federal court.
Well, but I'm not sure it does. What if somebody? All right, let's talk about this, because
it says serving the federal government. Serving the federal government.
We're serving the client, but what if somebody comes up, as officers of the court, we're also serving the federal government. So what if somebody comes up and says, I know a police officer, who is screwing around with all these young kids, right? And then this person's friend sees you talking, to a victim, and goes back to, Officer Smith, and Officer Smith then kills the victim because they saw you talking, they saw his friend talking to you and perceived that they were talking in federal court about this type of crime. I think the government could possibly slide in.
You've taken a third party's belief that you might be a government agent or officer and use that to fall under the definition of advising or consulting? No,
I just think that the fact that we're officers of the court, period, and we have our license from the court, that we are consulting or advising at all times, even if we're consulting and advising with the interests of our clients.
I think it's a stretch to say that is serving the federal government, because that's the language, serving the federal government.
Well, all right, so we want to hear what our new members have to say about this. Amy's laugh, new member. You didn't know you were coming into such a pivot. And this is a good question related to it. Would that cover mandatory reporters as well?
It might be on. And it might be on the final. What was the question?
Okay.
Would that cover? Would that cover? Was that, you mean the federal government issue?
Mandatory reporters. We're talking about, teachers and psychologists, psychiatrists.
Oh, I see. For those,
would they be serving the federal government?
I would say no. I say no. Right. I say the connection has to be much more direct than that. Either contracting with the federal government as a consultant, paid consultant. I don't think he can be somebody that just tangentially benefits the federal government. I think it has to be much more focused than that. That's just me. I haven't done the legal research on it, so feel free to check me on that.
Well, you may have to, depending on what happens with this motion tomorrow, right? Or whenever the judge rules, because I don't think you're going to get a ruling from the bench.
No, I'd be shocked. And it is. We have heard some things from this judge, but most of it's been on paper. I can't remember the judge's name. Do you remember it offhand? It's on the,
no, I do not. I do
on the
not.
document, but I can't remember. I looked it up earlier today.
Yeah, I don't remember.
Anyway,
oops, excuse me. I have to bend down and get my phone.
You're going somewhere?
Yeah, my phone dropped on the floor, and right now I'm in the process of thinking somebody's breaking into my cabin. So carry on as I deal with this. You're
not in the cabin now, are you?
No.
Oh, okay. You heard some sort of alarm or alert?
No, just some neighbor is worried. We have great neighbors. Okay,
Okay.
but it's not happening. Okay, we've clarified it.
Everybody's
It's
fine.
not happening. Everyone's fine.
Okay.
It's not happening. We're not going to be Guthrie'd. Okay, especially since we're not there. But this is we know who this is. That's is in our driveway. It's actually a worker. Okay, so
Okay. I hear the alarm, the sirens.
yeah, you hear that? I mean,
Going
we're
by.
here in New York City.
That's right. That's bedtime white noise for you guys. The court did so to reconcile the fact that the statute does not require the government to prove that the defendant intended or knew anything about a federal official, with the statutory language requiring the defendant's intended action to have a possible effect on a federal official. Now, that language helps your argument.
Yes, right. It does. Helps my argument. Right.
To the end, the court focusing
And then
on
it helps the government's argument.
Yeah, if they're trying to bring, everybody under their umbrella. Yeah. To prevent that end, the court focusing on the statute's requirement that the defendant act with the intent to prevent, discerning the meaning of those words, and held that the statute requires some minimal showing that there could have been something or someone federal to prevent. So that tells you this particular case is stretching that definition to pretty extreme lengths. Accordingly, the court held that the government must show that there was a reasonable likelihood that a relevant communication would have been made to a federal officer. Okay, so that's where we are with that part of the argument. Part two. Adequately pleads a law enforcement officer. This, I think, is a lesser issue, but anyway. Farwell first contends that the superseding indictment fails to allege that the offense was committed with the intent to prevent communication by any person to a law enforcement officer of the United States. However, he's wrong about the allegations in the superseding indictment and the requirements of Section 1512A1C. The superseding indictment does allege that the killing was intended to prevent a communication to a federal official. The superseding indictment uses the term of art from the statute, law enforcement officer. So they're basically implying that it's within the federal code. Therefore, any reference to a law enforcement officer obviously means federal law enforcement officer. Again, I don't think that's a huge leap.
No, the only leap I thought they were saying more in particular, you had no indication of what federal officer that she could be reporting to, that because this was a state crime. If anything, it's a state crime, and therefore that's why it falls, because you're just saying, well, it could have been, coulda, woulda, shoulda. Well, anything coulda, woulda, shoulda be a federal crime for the most part. You can always do, because you have dual jurisdiction in mostly everything. So that's what I think their argument was more literal.
Let's see if we take it. We're going to skip this one because we talked about the reasonable likelihood. That's them beating that proverbial horse to death. So we're going to get past the reasonable likelihood. Yes. Where's the next argument? They really get into the reasonable likelihood. Okay.
I'd like you to go to footnote 1 of page 12, actually.
Oh, let me back up. See also United States versus Kenney. We are not persuaded. Oh, is that your case? Is that against you?
No, but it's got sort of my name. It's got the it's missing an E, as most people try to email me and they miss the E, and then they say you didn't get my email. I said, and then they look back and they didn't have Kenney in my name. But I just thought that was kind of a fun notation.
All right, self-absorbed. All right, I get it. Oh, let's read it to make sure we know what it really means, what this Kenney case means. We are not persuaded that the Constitution imposes the additional requirement that grand jurors receive legal instructions. Okay, kind of an aside. Farwell, I almost said farewell. I think that was my subliminal thinking. Farwell also argues that certain additional facts must be included in the superseding indictment to satisfy the specificity requirement under 7C1. He contends that the superseding indictment is deficient because it fails to allege, here we go, whose communication Mr. Farwell allegedly sought to prevent, okay? And who would have received that communication? Well, I think we know who he was trying to prevent.
Right.
The victim of the murder.
Right.
The part two is what you're talking about. Who would have received that communication? However, here, where it is alleged that Farwell killed the victim before she could make any communication, no such specificity is required. That's a giveaway. Indeed, what Farwell seeks is information regarding the evidence the government will present to satisfy the reasonable likelihood showing articulated in Fowler. A request for more detail where is necessary to enable the defendant to prepare a defense, to avoid surprise at trial, and to protect against double jeopardy is resolved through a motion for a bill of particulars pursuant
There
to
we
federal
go.
rule.
Bill of Particulars. Yeah.
So that, again, is not the most important part, not the number 2 part. To satisfy Rule 7C1, the government need only allege the elements and statutory language. Yes, I think we're going to get past that. Let's see. Farwell argues that the Supreme Court's decision in Russell requires that the superseding indictment include specific facts about a communication that never occurred because the defendant killed the victim before she could make it, which is very convenient and supports the reason the person killed the witness. He did the job, if he did in this case, before she could squeal. That's the whole idea.
That was the idea of eliminating a witness.
And that's
You
why I
don't
like
want
it.
to. Yeah.
It says, first, Farwell's argument demands a metaphysical impossibility. In Russell, the Supreme Court held that indictments charging defendants with refusing to answer questions during congressional hearings violated the code, were deficient because they failed to allege the subject matter under investigation. Russell, the court held that a statutory element, in fact, the core of criminality of the offense, was whether the question the witness refused to answer was pertinent to the subject under inquiry. That is so far afield from what we have in this case, which is a murder case.
Right.
Here, the specific contours of a communication that all parties agree never occurred is very different from the subject matter of a congressional hearing in which the defendant participated. Russell requires the indictment to allege something that happened. Farwell asked for specific allegations about a communication that never was because of his own conduct. In other words, he did such a good job, if guilty, that he prevented the communication he wanted to prevent. Okay, now here we go. We're ready for this part?
Okay, I'm ready.
Russell required the indictment to include facts identifying an element, the subject of the inquiry, to help the defendant defend against the allegation that he refused to answer any questions, blah, blah, blah. Yet Fowler is not about the sufficiency of an indictment under Section 1512A1C. It's about the evidence required at trial. Now, that's a huge distinction because this is a pleadings attack. Let's see. I'm going to get to the showing of who, because this is the big issue here. Who would they have talked to? Let me make sure I can find it.
And that's a big issue. Although, the way this is set up is that the court could say, "Hey, you defense, you haven't asked for a bill of particulars, therefore you can't make this motion because it's not ripe yet." That's the word we use in law.
Not ripe. It is not ripe. It's either moot or it's not ripe. Let's see. I'm skipping some of the details of Fowler. Farwell takes Russell's holding about the sufficiency of the allegations concerning an element, the core of criminality, and invites this court to apply that pleading principle to Fowler's holding about the quantum of evidence required to show that the defendant's conduct could have prevented something federal. The court should decline that invitation to require the indictment to plead evidence related to Fowler's reasonable likelihood standard and hold that the superseding indictment is sufficient under the rule. Farwell's Fowler-based argument about how the government will make it reasonably likely showing is an issue that may be resolved through
a bill of particulars.
Not
ripe yet.
Here?
Don't eat the green ones. They're not ripe yet. What movie is that from, everybody? What movie? There's a famous movie. Don't eat
what
the
was that
green
again?
One. It's not ripe.
What? Green Tomatoes.
No.
Dang it. I don't know what that is. What movie?
Well, the female star is Jamie Lee Curtis. So I'm just going to give a little hint at a time.
Trading Places.
No.
Is it one of her newer ones? The one where she won the Academy Award? No.
Yeah, the one she won the Academy Award for. Yeah. Yeah.
I don't know what that one is. What is it?
No, we'll wait.
Okay. Somebody's going to spit it up? Okay.
Somebody's going to actually spit it up.
True Lies?
Not True Lies.
Okay.
It's funny. It's
a funny movie.
It's funny. Think about Monty Python star. Come on, everybody. We almost should give a mug out for this.
What? I must have missed this movie.
You'll know when somebody comes up with it.
Okay, we'll circle back. Okay,
yeah.
Yell when you see it. Blah, 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 blah.
A Fish Called Wanda. Sheila has it.
Yeah.
Sheila, that's perfect. You would have
That was not one of my favorite of her movies. So I
Oh,
don't
but
remember that
really,
line.
that's I think the supporting actor won an Academy Award there too. It was just fun. It was funny, you know. It's
You know what
Ken. It was Ken. Don't eat the green one, Ken. It's not ripe yet. Talking
And
about
what were
the fish
they talking about eating?
because he loved his fish tank, and you know, he was being quoted like blackmailed, like don't eat the green one. People to get him to give up information. You have to see the movie.
I guess so. I just wondered what
John
the food
Cleese. There
item
you go.
was. It
Yeah,
was green.
it was a
What's the
green
food?
fish. It was a green fish in
Green
the fish
fish.
tank. A little tiny
Oh,
fish in the fish tank. Yeah.
here's where I think there's a problem with this response, because your concern, which had to do with identifying a person,
Right.
they don't really address it in here.
That's what I thought this was about. I thought it was a
No,
person.
they keep circling back to the specificity and the likelihood that they would have reported it to somebody had he not killed her.
Right. And they go through, I think they say at some point there was an issue of, was it remember when a friend, there was a call to the police station to say she was going to report, she was going to report them, right? She was going to report them. And that came in through, I forget who, a female, but I don't remember the name. I don't remember if it was in the bill, not the bill in particular, but it was in the pleadings. And that's what the government seemed to go back on. And therefore, she could have reported that reported that to the person that she called in the police station. She could have reported that to the feds, but
yeah,
coulda, woulda, shoulda.
Yeah, I mean, that's very tenuous, but is it enough? But I just think it's interesting. They raised the issue, and I'm slowly scrolling, but they, in my opinion, they don't even address it.
Yeah, they don't address it.
They just mention it as one of the issues that has been brought up in prior case law. Maybe because they really didn't have much to say about it. I mean, I don't think they can ignore it. That's a huge issue, because if they're asked to amend, the court could specifically say you need to provide information indicating whom that federal official or law enforcement official would have been.
And they're going to end up saying it could have been anybody that well, maybe they have an interview of the person, and we know the name of the person. Mizzy and Barb have told us a number of times, called in to say that Sandra Birchmore is going to go public with these allegations, called the police station, and then they told Farwell, and then she's soon right after that unalived. So I mean, I think that's, and maybe they have an interview with her that has been turned over to the defense, or it hasn't been turned over to the defense, because remember, in federal court, you don't necessarily get all the discovery like you do in state court until the very end. Yes, Kyle Sharkey knows Kevin Kline won the Academy Award for Best Supporting Actor. Yeah, right. See,
Kevin Kline. Yeah.
You won't get this discussion anyplace else when we're discussing the Farwell motion.
Yes, I'm pretty sure of that. I may have to give that film a second look, because it wasn't. It never really resonated with me. What year was that? Like probably 85.
Oh, probably
90?
88 maybe. I think around 88.
Must have been busy. Must have been busy doing something then.
Everyone can look it up and then put it right in the chat. Fish Kowano. It was like 88. Could have been in the 90s, 92.
Yeah,
it could have been 92. You know.
Okay, so
95.
Here's where I think they've got their response. I think has a problem, and that is that they don't specifically address that there doesn't seem to be evidence of a specific person,
which is why
not in the superseding indictment.
Yeah, which is why this motion is being made, and why everyone's saying if the court interprets it that it has to be a specific person or a specific group of federal officials, then this motion has some legs to it. If the court says no, because you can glean that because of that call that was made to Ms. X at the police station, with Sandra Birchmore was going public with it, and we, therefore, she could report it, or anybody could report it to the federal government, and therefore you have that, it's not so tenuous. You have that connection, And then again, maybe the one thing also we don't know about is whether or not there was already a federal investigation. 1988, Philadelphia. I got it right by just guessing my first one, right?
Oh, see, I put it right in the window, 1985 to 1990. I knew it was in there, but you were right. You had the right. You must have loved that film.
I just remember, I mean, how could you not remember anything that related to Monty Python or Jamie Lee Curtis or Kevin Kline? He was so funny.
Yeah, I like him. I like her. I think I was never a major Monty Python fan. I think that's what it was. I think that's what it was. I don't know why, but I wasn't. Okay, so there you go. That's what we're going to hear argued tomorrow. And
Okay.
by the time in fact, this is a good point, a good time for me to mention. Tomorrow at 4, a members first will be talking about the detainment letter the prosecution put together to keep Matthew Farwell in jail pending resolution of this case. So we're going to do that tomorrow at 4 o'clock live. That will be a member first. And at that point, they will have already argued this. We, of course, won't know anything because they will not have the stones to make a decision from the bench. But we can still talk about the fact that it's already occurred and that whatever the details might have been. So.
Yeah, and we may have some reporting by then. Maybe we'll give Missy, maybe we'll Sheila, maybe we'll give Missy a call and Barb a call, see what's happening. Cause I'm sure they're going to be in court and posting about it.
Yeah, I would hope so. And in fact, I think they're doing a pseudo standout.
Right. Like the federal court.
Like at 10 o'clock, because the hearing's at 11:30. I just read that note, so that's at the bottom of the screen there from Courtney H. from Florida. I don't think it's you, Courtney. I hate to break that news, but I'm trying to find the winner's name here, or at least the winner's.
Of course, sorry, but he's taking a look at it. He knows who the winner is because I did see it was in your email, wasn't it?
It was.
It was in the Justice Serve TV email. I did see that. Okay.
I'm
taking Farwell off the stage.
I will say it was Kristen was the winner. Kristen.
Where were you, by the way? Where were you?
St. Pete's Beach, which is an amazing beach.
Somebody put that right on Twitter, by the way. Somebody had that first thing under when you posted
that might have been
Twitter.
See, that might have been the guy that was so mad. There was a guy that commented that I answered twice correctly and keep your stupid mug. Well, the comment has to come through YouTube, or we don't, right under the segment that's Where in the World is Justice. I mean, I guess you could send me a letter as well, but I'm probably not going to see that. So keep it, to the comments from the video itself. It's just simple that way. So congratulations to Kristen, and we will continue to do that as I wander about.
Yeah, Kyle says busy end of the week. Farwell Thursday, Karen Reed Thursday. By the way, Wednesday we have Mike Easter on to talk about all 3 cases. All 3 cases on Wednesday, and obviously Thursday too. We've already put up our thumbnails. They may change for the week. And I think Friday we're going to do a pre-record on a show, by the way, to be released at 6 p.m. as a premiere on Friday, just so you know. Yeah, and that will be
a comment show, which I teased actually today when I mentioned what was happening this week. I said we haven't done a comment show in a while, and I referenced the person who was so mad that they didn't get picked for the Where in the World is Justice mug. So that's why when you said, what about comment shows? That's a great idea. We haven't done one in a while.
Yeah, but we do have Easter. We're not finished, by the way, this show yet, because we still got KOURI Richins, but we do have Data Daddy coming back on. He'll be talking about Kelsey Richins, whatever is out there. And then Thursday, also alien immunity, not just Karen Reed. No, I didn't even put Karen Reed on the thumbnail. Alien immunity. You know why? Because the witness list has to go back. And so we have to know whether or not they're giving Justin the alien immunity by Thursday, it seems to me.
It was definitely... trickled out there in the hearing, that
That's true.
He said that, like a throwaway line. Well, if he has to testify, we'll give him immunity.
Yeah, well, right. And the court said, he didn't grant the discovery with Noonan only because you have to go through Rule 17 apparently. But he said he was holding the decision on the other stuff until the government answers on. The issues that they laid out in court, which I assume that answer has to come by the witness list.
Yeah. You would think. And then the DA for Essex County, oh my gosh. Really, to the Michael Morrissey school of DA assholery.
Yeah.
Because he's justified not, what's his name again? Do you have his name handy?
No.
Somebody who does such a poor job should be outed. I can't remember his name either. Anybody know his name? The Essex County DA? He decided not to charge the alien with anything. Why? Because he called the cops first. Called.
Yeah.
Called.
Well, I told him I'm living there without
the
fact that you lied because you had an affidavit that said several days before that you had moved out. Okay. All right. So it should be really interesting on Thursday. So we had a good end of the week. But we also had KOURI Richins on today. the
Yes.
trial. It was really interesting, even though it was all day. First we all rolled our eyes. Forensic account. Yesterday, by the way, when they ended with the digital data person, with all the texts and the Google searches. The Google searches, I don't care. As far as I'm concerned, the Google searches are going to sink her and all. But this was a very interesting day. It was going on when we were still on the air. They were just finishing up, as you saw. And this was the forensic accountant. She was the accountant initially for the estate, but when the estate changed lawyers, she was terminated from that position, and then the government hired her to be the forensic accountant here to show us how much debt KOURI Richins was in, and they were all coming due. And then when her husband died mysteriously, and then later determined to be fentanyl poisoning, she already gotten the 3 insurance policies and was paid off a lot of the debt and was selling things. So she was out of that. She was
The
out of
numbers
that gray area.
are pretty impressive.
Well, I'll tell you what, she had $2,100 a day of debt due, just and stuff that was due. That was enough to fund me. That's enough to fund. I could fund my clothes and shoes wardrobe with that.
Is that enough for your purse account? That $2,100
Yeah,
a day?
geez.
I don't know. So this was all about, she had this flipping business, basically a real estate business, KOURI Richins LLC, or Realty LLC, and that she would do is buy homes, fix them, throw lipstick on the pig, and then sell it. And it's a very interesting, exciting biz. HGTV is full of shows where they do this. I've done it. I've only got 2 properties at the moment. I've had many more, and I've done both buying, fixing, and flipping, buying, holding, selling after some appreciation. And it is, for those who aren't as familiar, and you hear all these numbers being talked about, it's a juggling act quite often, because you've got various loans on properties you are acquiring, properties you own, properties you might be selling. Sometimes, you've got a loan on a property being sold and you're hoping it closes in time because you need it to move that money over to this place. So that didn't concern me as much as just the big picture, the overall chunk. She and the growth, which I think she did a great job. I don't know if I can find that. I'm going to take a quick look. Oh, there it is right there. I found it right there. This is the growth of the KOURI Richins business, which will sink you if you don't know what the hell you're doing. Let's see if we can.
Okay. Any additional objection, Ms. Nestor?
Not other than what I've already covered, Your Honor.
Okay.
And she, by the way, these objections, she was so mad because they started getting into tax returns and stuff at a certain point. And of course, the judge had to instruct the jury more than once. If you're going to listen to this information, it's about. You can't find that she may have committed some fraud or other acts. That's not in front of you, but you can consider it for motive. And man, is there a lot. There's a ton of motive. And remember, motive not an element, but it does lead you to intent, and it can, under circumstantial evidence, get you where you need to go, Mr. and Ms. Jury.
Yeah, especially since you've taken that like $25,000 out of one of the last life insurance policies and sent it to your boyfriend, who, by the way, you had been texting right after your husband died. Will you marry me someday?
Everybody grieves differently.
This is true.
Everybody grieves differently.
Okay,
let me see if I can get to.
For KOURI Darden, Richard.
These are. I want to get to the pyramid she put together. Hold on, stand by.
From that.
Oh, look at KOURI today. Very, she was very animated. This is not one of those moments.
Oh yeah. Oh,
she was like and leaning yesterday. Over.
Yeah, yesterday she was. Yesterday she was like the Wicked Witch of the West in animation.
She had Post-its and handed. There we go. Check this out. Check this out. So 2019. This is KOURI Richins Realty LLC. And in 2019, a very modest purchase, $215,000 property, fixes it and sells it. The next year, she jumps up tenfold, only 5 houses, but 10 times the valuation, almost 3 million. Okay, now that's aggressive. Let's go to the next year. Triples that number to 6.7 million, 15 properties.
Wow.
You're screwed. Unless you got some major backing from either hard money lenders or conventional lenders that just see that you're just going great guns, and we trust you and we believe you. So here's a ton of money. Here, have $6 million. Go to it. That's rare. You got to grow.
They were explaining that she did have with hard money lenders, and you want to tell us what that is, Michael?
Hard money lenders are brutal. She overexpanded, and hard money lenders, that's like loan sharks. It's like legal loan sharks. You know, you don't want to go through that crazy credit check stuff with banks. Blah. So you just go to somebody who charges you, 20% interest on a very short-term loan, and here's the gob of money you want. And of course, they're still protected by the property. So if you go belly up on the loan, they still can get their money out of the property as long as they're in the first position. If you're a second mortgage, third mortgage, you're probably going to be screwed. But these hard money lenders give her $1 million at 20% interest. The VIG on that, and I say VIG because that's more like gambling than traditional loans. It is so high. The numbers were outrageous. How much she had to come up with just to pay the debt service,
right,
on these loans.
That was right. It was huge.
And then they also. So I want to show you that just to see the growth. And then obviously 2022, which is the year that Eric Richins was killed, she dropped back down to one property, and that's the mansion. That's the mansion that we've seen pictures of. We heard about. She was buying it for 2.9 at or about the time he was killed. I mean, it was just right on the.
It's like 12,000 square feet, 13,000 square feet. I think she closed on it right after he got killed. Right after, like right after.
Well, I think if I remember, they closed on it and were celebrating that day or that night.
Right. They were going to close. Supposedly that's what they were celebrating when, according to the government, she laced his drink with fentanyl, and then he just went to sleep and never woke up.
Yep. Let's see if I can find another graphic that's helpful for us here.
I have to tell you that I actually did think Nesta did a good cross-examination until she didn't. Today, you could ask that one or two questions too much. All right, and that's what happened.
If I can find her for you and just see, give folks a taste of the Nestor language.
But it's the whole thing. It's the fact that she was having marital problems. The fact she told people. It's the fact that she told her husband on Valentine's Day, well, the sandwiches are for you on your car truck where no one else could get to them. That she was with him. Poisoning is a very intimate crime. That she went to. They actually confirmed, as far as I'm concerned, by the cell phone service and the cell towers and all, that she was close to the two drug dealers that she was getting the drugs from. I think it's a whole package. To me, this is a very difficult case to win, although all you need is one. And I've seen people say that they think that is reasonable doubt because you can't prove he didn't take the drugs himself.
That's right. And we still have that very important lack of evidence about testing the pill bottle for fentanyl.
Right.
How do you know it wasn't in there? How do you know he wasn't taking them and the pill bottle's empty because of it? Take a look at this shot. First of all, I froze it in that. That's a flattering shot. There were so many others who were unflattering. I got past them for Ms. Nestor's benefit. But look at over here in the bottom right. See that person right there? I'm going to try and put the cursor on her face. That's the sister.
Okay.
The sister. Now, this is the one who was sued by KOURI Richins because of the trust. Because the trust locked KOURI Richins out. She didn't like it. She sued the sister and the family. The sister represented them. She was the face of the case.
And you did hear the forensic accountant mention the lawsuit. I can't tell you how many times.
Yes, I know. And I'm like, yeah, because that was, and Nestor was asking these questions, and she led right into that. She would ask a question where the answer was, well, you mean when she brought the lawsuit? Yeah. And I know that I know there were jury instructions at one point about to ignore that stuff, but the jury keeps hearing it. They can't ignore it forever.
The judge lets in a lot of hearsay and says you can only hear, you take the one side that's admissible, and then you have to ignore the other side. But they've heard it all. They've heard everything. And I love this judge, by the way. I love his voice. I love the way he runs his courtroom. And he's probably right on his rulings because the defense leads into them. So you object, but then you've led yourself into them.
Yep. Okay. Let's do a touch of Nestor here.
Okay.
Jury has just come back from a little bit of a break.
Nestor?
This is redirect. Let's see. I know that was a argument outside the presence. So let's skip ahead to get Nestor up here. She really didn't have all that much.
No, but I think she was explaining that everyone knows that, hey, look, there's a lot of float and all this kind of stuff when you're rehabbing. You're in, you're out, you're in, you're out. You're trying to sell, you're trying to flip, and that makes sense to anybody that knows about the rehab business, right? But that's not what this case is about, I don't think. But
no, I think you got to take a step back because you could get lost in the minutia because it is that kind of business. That's why your
That's
sphincter
right.
tightens daily, because you know you don't know where that money's going, and is it going to be in time? Is it not going to be in time? Am I going to lose this deal? You know,
Right.
it's that
Something
kind of
that's
biz.
new that I don't think you've ruled on at all, I
Oh,
will
wait.
let the court know that.
I appreciate that.
Thank you.
Okay, so again, that was one of their issues they had about. She had a continuing objection to all those tax documents, and the judge was just saying, if you have additional grounds, then please tell us. Come on, Ms. Nestor. And they know one another, apparently, either from the trust case, perhaps.
Yeah.
But she made it clear, Ms. Nestor, that she knows this witness.
Yeah. Oh, yeah.
Let's have another break. Now we should have Nestor time. Come on, is the Nestor time there?
Sure.
We go.
And we did hear you talk about that on direct, but just as a quick refresh, because I think that was 20 years ago.
That was her
The
joke
hard
about how
money
long the direct
lenders-
That's a
was.
joke, right?
Lend money without all
Joke.
of the formalities that a bank requires to lend money.
Hard
right?
money.
For example, that is correct. For example, the underwriting process is almost nil.
And to
Vito,
sound
I need a
really
loan.
kind of juvenile about it, it's basically wealthy people that are willing to loan you money short term for a short period of time at a super high interest rate, right?
Right. And they assume the risk of that. And in exchange, they have very strict zero tolerance default clauses that make a loan just skyrocket in cost and interest if it's not met, if those terms are not met.
And the reason for that is this is a risky business, yes? For both sides.
I'd say it's risky for the borrower.
And for the lender,
Oh,
because they're not putting someone through all the vetting that a bank would. They're
secured.
just trusting them that they're going to show back up in 90 days and pay them off.
It was secured by the house. They have that. They have the property.
Secure
That's what
that
she has to
property
educate her.
with their trust deed so they've secured their collateral.
Totally fair. That's absolutely right.
I do like the way
So
Nestor basically says, yeah, I
riskier
screwed that
for
up.
the person
You
that's
got
doing
me.
the flipping than it by far than for the hard money lenders.
Yes.
By the way, this expert
Hard
that
money
was paid.
lenders
This
generally-
expert was just paid $200,000 by the state.
Oh,
for the
I was a
forensic
little
accounting.
surprised at that. You probably
$200,000 by the. I wasn't a little surprised by that, but for those of us who know people who don't charge enough, or you get a bill from an expert and it's like $1,000, and you say, "Wait a second, you did all this work. Thank you very much for doing all this work for that kind of money." But she charged $200,000 for, and that's not
$200,000.
including testimony.
I was a little surprised, but it is a very
Complicated.
intense process to whittle it down to what she was testifying about.
Right.
They didn't talk about her hourly rate, but yeah, I thought 200. I thought maybe 100, but she had binders, a lot of binders.
Do not expect to get paid monthly payments in between when they loan the money
They
and when they
could.
get paid back. Fair?
Well, it depends. And I think that's usually a true statement. KOURI Richins had most of her loans that were like that were 6-month balloons. There was nothing expected. In fact, when the subpoenas went out, I expected to get all these ledgers back, and nobody has a ledger because they didn't care. They just knew when the balloon was due, and they were going to get their money or their property.
Man, that is so scary. These balloon loans, they were getting 6-month balloon loans, right?
Right.
That 6 months comes up fast, and it
Right.
is powerful because you're doomed if you can't meet that balloon, and if you have to renegotiate.
Your kneecaps come off. Or is that what
That's
you're
what she said.
saying?
Nobody has any ledgers. What, Vito didn't keep a ledger in the trunk of his car where he had his guns? Yeah, I mean, you don't know who's going to come up with this hard money. It is like loan sharking.
Wow.
It's legal. Okay, let's get a little more of her
Exactly
action.
right.
Miss Richins had 3 property. Well, she had 2 lenders that had monthly payments.
And because of what you just said, the hard money lenders have what we call a promissory note, just a promise that if I don't pay you like I promise on this note, you can get the value, you can get the property and sell it yourself and recoup your money, right?
Just another ignorant statement that Every lender gives a promissory note. You know, Wells Fargo has promissory notes, not just the hard money. I just think she made herself look ignorant and allowed the expert to sound really like an expert by
Right.
setting up those kinds of questions. Listen to this.
Yeah, there's a
answer.
promissory note on any kind of a loan.
So when you put all those loans up there, they're backed by the collateral, the house.
Can you clarify which loans I put up where?
Sure. And that was a broad statement. So
I just want to make sure we're talking about because the loans I put up there are the payday loans, and those are different.
I'm talking about the hard money lenders.
Okay.
When you showed some notes, for example, where I think Matt Strong paid a couple $1 million on one property. Somebody else paid $300,000 on another property. All those loans were backed by the property. They were totally secured.
For the first position lender, they're totally secured. The others are secured with the property, with the caveat that they are in second, third, and fourth position. For example, the Midway house, the Legacy Way house, the second, third, and fourth position lenders did not recoup any of their funds on that.
Second, third, and fourth. Here's what I like to say. The first always gets paid
The
back,
money.
right?
Right.
The second, third, not so much.
Right.
Did you see
Right.
that maneuver? You didn't see that maneuver.
No, I didn't see that move.
One more time. The first always gets paid. The second
Okay.
and third, not so much.
Okay, I saw that
Okay.
maneuver. Michael Bryant is back on
No.
Justice Serve TV.
So two things I want to talk about before we wrap this up. Oh my gosh,
Okay.
it's past my bedtime.
Yeah.
The tax returns. Interestingly, KOURI Richins did tax returns that inflated her earnings. So she might state the normal amount of earnings, but she would limit the deductions. Why? Because then if she's selling her business to a lender just to convince them to give her money, it looks better on paper. So she went as far as to actually pay more taxes than she might need to, because the goal of any business is to minimize their income, therefore minimizing taxes. She didn't do that. Very weird, very, very backwards way to do it, but she did it with a purpose, to get those loans from whoever she felt she could get loans from.
Right.
And the other thing was, just a simple thing she had on her website. She had a little statement about the company and how she's doing. And she said in that statement, 147 employees, apparently based on the payroll going out, maybe not, maybe not 2 or 3 employees. So she's doing a little puffery there. Okay, all right. And she also said she had $1 million of profit in this very short period of time. And the accountant's like, no, I don't see that.
No.
So again,
No.
the goal to entice lenders of some sort to get in bed with KOURI Richins, so to speak.
Yeah, absolutely. Well, I think the prosecution was slowly forward marching with the motive today again, but I'm still waiting for what am I waiting for? The walk the dog letter.
Walk the dog. Let me blow
Walk the dog, maybe by
off.
tomorrow night. But we could also
this
talk
may be the coup de grace. They may be waiting, till the end of. I haven't heard an update, but I believe they were going to be into the 3rd week for the prosecution. So this is the middle of the 2nd week, and they are not doing this Friday because they did last Friday to make up for Thursday's mess. So they'll be done Thursday. Then So I'm thinking maybe next week. I'd put that near the end of my case if I were the prosecution.
All right. So tomorrow night, Easter comes early. Easter comes early.
I like that.
I threw all the cases out there, figuring which one he'll pick, which one he wants. All of them that have digital data forensic evidence, and some that should have digital data forensic evidence, like Guthrie and Doan. And we'll see. In the meantime, we have the alien going on, and I know there's a lot of talk about Karen Reed and Thursday and Friday, but we'll probably cover what happens in Karen Reed next week after all the dust settles.
All right. Yep. And tomorrow we'll have the hearing, and we're doing it live, 4 o'clock, members first, where we go over the Matthew Farwell detention document, tell you why the feds think they got their man and why he should be in.
And then 6 o'clock, we'll do the actual show with Mike Easter.
Yes.
All right.
Correct.
So subscribe to not miss it. Subscribe, like, share, notify, and hype. Subscribe, like, share, notify, and hype. And then because you're here. I don't necessarily have to turn the show over to somebody else who would like to take your
yeah,
position and be co-host.
I will do that, and I will still, in honor of my friend Savannah Guthrie, tweak our normal outro and say it is never too late to do the right thing.
It's